Happy Tuesday. Wait, no, but on a Wednesday. Look, traveling has made me lose a day this week. I don't know if that's how you feel too, getting ready for the holidays, but I'm like, it is just, it is just. We had a few technical difficulties this morning, but we're all here together. We have so much to talk about. I was putting down all of the different topics that I'm going to try to cover today, and I was like, oh dear, this is going to be a lot. Some of them we're going to have to do briefly. Some of them we're going to do a little more of a dive into. Either way, we're going to cover it all today. I've got coffee. I've got Cursey words. We're front and center. I've got my steel colored, like my more black colored earrings on today because I haven't worn them in forever, and now I remembered why. They do not show up at all. So there they are. But it is. It just is. Today's going to be a busy one, y'all. I hope you're, either if you're getting ready for Thanksgiving, that you are able to have this on in the background and just enjoy with the rest of us. Law Nerds, it's so good to see you. It's going to be a busy week. I'm glad to be here live. Hopefully, you're glad to be here live. Let me know where you're coming in from, what you're drinking. Bulletproof coffee and lots of water for me. And we're just going to get rolling because today we're talking about. Okay, we're going to talk about a few of the criminal law things first. Replay crew, love you. There will be timestamps at the end of the stream. I'm going to talk about the Waukesha. I'm hoping I'm pronouncing it right. The parade killings there, just really briefly. The Rittenhouse verdict, waiting on the McMichaels verdict in the killing of Ahmaud Aubery. The new information coming out in the Brian Laundrie case. And then we're moving on to our pop culture goodness with Stuart Smith, also a criminal case, changing his plea, 2 new Britney filings. And finally, there is a very interesting ruling in the Triller H3H3 Ethan Klein lawsuit. It's very Triller-y. There is a transcript attached that the court attached. So we get to talk a little bit about what happened in court this week. Waukesha, thank you, everyone. I pronounce things terribly. We appreciate it. So yes, all of that. We have lots to cover. And I'm all cozy. It's like cozy season. I feel soft and cuddly. It's cold in Middle Tennessee, and I love it. Like, I love it. I love it. So, everyone, are we ready to roll? I'm ready to roll. Should we just roll the intro? I appreciate it. Devlin, everyone says it wrong. I would like to say things right. I appreciate when you guys help me out with that because, I look, it's just one of the things I struggle with always. So let us cheers to some coffee. Let us roll the intro and let us get right into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. We are here to talk about facts, and law nerds, I appreciate you. We are going to be talking about some polarizing topics today, which I understand, but we are here to talk about the facts. Y'all, I know y'all have your own feelings about all of it, and that is totally fine. But what we don't do is the name calling and the disparaging and all the things. I'm going to give you my thoughts on some of the stuff that's going down, but I'm also doing a new I Have Thoughts episode for the Patreon crew. If you are not over there and would like to be, Patreon is lawnerdsunite.com. It will get you over there and you'll have access to the members only streams, different benefits by tier, and of course the I Have Thoughts podcast, which is exactly that. It is me having thoughts because I do that. I do have thoughts. So that's what's going on over there. Let us get into our first 2 topics before we move on. Before we move on too fast. The stuff going on in Waukesha, I've not seen a ton of coverage, and it's staggering to me that I haven't seen more coverage. I should say that we're getting into quick bits. I should have said that at the beginning. I should have swooped. Look, we're professionals here. I just want to sit down and talk. And so it's gonna be like that today. Look, it just is. I should have said we're getting into quick bits because we have some quick bits. Quick bits. Yep. Quick bits. It's Tuesday. We're doing quick bits. A lot happened while I was traveling. I'm feeling super scattered today. Like getting ready to do the holidays is a lot. Traveling over the holidays is a lot. We went to a family wedding last weekend. We got back at like 3 a.m. the day yesterday. Yeah, yesterday. I don't know what day it is. Yesterday. So it's been a lot. But as we talk about that, there are a lot of families that are having just a horrendous holiday season, a beginning of holiday season, with over 6 dead now in the Waukesha killings. What I've seen is a lot of people questioning what's going on with the bail and how Daryl Brooks, the person who the police said seemed to be aiming for people and zigzagging down the parade route to try to take people out and strike and injure as many people as possible, how he was out on bail. Look, different states have different bail regulations, have different bail rulings, and he was out on bail. He had out on bail charges multiple times. And I think this is a push, there is a push pull to make sure that people aren't kept in custody for, ages and ages on cases where they wouldn't even get sentenced to that much time, between keeping people in that are a danger to the community. And this is a push pull that is going on in communities and in states and in counties all across the US, trying to figure out what that right balance is so that things like this don't happen, because he had been out on a lower bail after attempting to run over someone he was in a domestic relationship with. He is now on a $5 million bail. So that is probably going to be enough generally to keep him in custody. So it is one of those push pulls that is hard to wrap your head around, when you're like, okay, well, but these other things happened, and how is this person out? And that is part of the push pull in this system. I've said push pull like 600 times, but it is really that. It's trying to find the balance between how you make sure that not everyone just sits in custody indefinitely because they don't have the money to pay bail, and protecting the community. And that's absolutely um one of those things that is not a perfect equation, and really does take an evaluation of each individual, as it should, each individual case. And the system doesn't always get that right. And in this case, he was out, and I think, a low bail on a domestic violence case, which was the case that he was out on bail on when this happened, is always going to be dangerous. So it's just, it's just, it's just a tragedy. Uh, Lots of lives lost. I think there were lots of opportunities for this to go differently. It seems that the police saw the vehicle coming towards the parade route and tried to stop it. It's really just a tragedy all the way around. But the alleged perpetrator, the driver of the car who has been charged again, is innocent until proven guilty in a court of law, is facing 5 counts of first-degree intentional homicide. Each of those carry life without the possibility of parole. That will probably grow as, unfortunately, people have continued to pass away from their injuries. And as that happens, I think we will see the counts go up. Will this go to trial? We don't know. This is at the very early stages of a criminal proceeding. There will be there was an arraignment. You can find the video on that. That was yesterday. There will be then a preliminary hearing going over the initial evidence. Then there will be all of the court process going forward to whether this goes to trial or whether there is a plea deal in this case. Generally, plea deals don't happen in these types of homicide cases for low amounts of time. It could be a very high amount of time, but we will see. We will I will keep an eye on this and keep covering it. I think it's going to get polarized. Some of it already has gotten polarized, which doesn't help the families of those who were lost recover in any way, because their family was lost, whether people are using this as a case to talk about whatever their particular viewpoint is. But the facts as we have them are that, way too many people were hurt at a Christmas Day parade. Um, 6 have passed, and it really is just a horrifying tragedy. So it will just continue on. I saw that Chad over on the Facebook asked a question. Will they add more charges, or do they have to file them additionally? They will add more charges to the original charging document, and then we'll add more charges to that charging document, and then we'll arraign on the additional charges. It's just horrifying. So that is what is going on. So that's what's going on. Speaking of polarizing, we're just going to get into all the polarizing shit first, and then we're going to get to the pop culture shit. So let's talk about the Rittenhouse verdict real quick. I'm going to swoop it, and we're going to do it. I know there are strong feelings about this verdict. There are strong feelings about this verdict. I personally was not surprised that when they came to a verdict, that it was a not guilty verdict or an acquittal of all charges. I didn't think that the prosecution proved enough evidence in the Rittenhouse case to prove this case beyond a reasonable doubt, and to prove that Kyle Rittenhouse did not act in self-defense beyond a reasonable doubt. The facts weren't there. The proof wasn't there. What I don't like seeing in this, again, this case has become very polarized, is like the Rittenhouse media tour. I know that there's been criticism of the people around him, from Robert Barnes and others who have worked with this case and do not work with this case any longer. I think it's the media tour is confusing to me and seems like a terrible plan. So I'm confused as to why that was the choice. That was a choice that was made. I think that this has the defense attorney really said it best. Richard said in his closing argument that this case is a tragedy for all involved, and it is. I know a lot of people feel that, Kyle shouldn't have put himself in that situation. I agree. I'm a mom of a 13-year-old. I wouldn't want my kid in that situation. The thing is, that doesn't count when it comes to whether this was actually a self-defense case or not. And the facts are that it is a self-defense case. Do I think that this should have been a case where Kyle Rittenhouse got the verdict that he got, and then maybe laid low and started the very long work of recovering from the PTSD of all of this? Yes. Do I think that that would have been maybe a more respectful option? Yes. It's just not the choice that's being made, and I don't love that. I don't think that Kyle Rittenhouse is a hero of the world. I also don't think he is, a demon murderer who went there to just slaughter people. I think he is a 17-year-old that made bad choices, that landed himself in a situation where his life was in danger, and ended up taking the lives of 2 people that will probably stick with him for the rest of his life, and that he is not really to be made out to be a hero or the worst thing in the world. And that's what it is. So I am not surprised by this. The law and the facts were on his side for this. I don't think the prosecution should have charged this at the beginning. I think that with the videos, there weren't enough facts to prove this beyond a reasonable doubt that it wasn't in self-defense. So Alex is pointing out that he didn't cross state lines with a gun. The facts of the Rittenhouse case we've talked about a bunch, and I streamed a number of times with Nick Rekieta on his channel while we were watching the coverage of this trial. I watched quite a lot of the testimony and quite a lot of the arguments, and the facts are that he was in a position where he could use self-defense, and the jury found that the level of self-defense, meaning using a weapon, was reasonable in this situation. So I see another question, and normally I get to questions in the end, but it's a great question, and I want to address it while we're talking about this before I move on. Can there be a civil suit made by the families now? Not easily, because the jury found he was acting in self-defense. So the wrongness that you would normally see in a civil suit, like in the OJ Simpson case, where there wasn't enough or beyond a reasonable doubt, but there was enough for wrongful death. I don't know how the self-defense being what was believed by the jury will play into a wrongful death civil suit, because is it legally wrongful if you are acting in self-defense? And in most states, that would break down to a no. So I will be interested to see how that goes. Again, that's going to be under the laws of Wisconsin. I don't practice in Wisconsin, but those are kind of my initial thoughts on it. Um, it shouldn't happen is really where we're at. It just shouldn't happen. So, and I see Lauren saying Rittenhouse should have been charged with illegally buying a gun. He was charged with illegally possessing a gun, but it wasn't illegal to possess under the laws of the state when he possessed it. So that is what it is. Um, Tahaney asked, why was he carrying a gun in the first place? He testified, and this is again his way of explaining it. He testified that he was asked by business owners after days of protests in the day turned to riots in the evening to protect their property, and he was legally allowed to carry that level of a gun. Do I think that was a bad choice? Yes, I do. But he was one of many. I mean, almost everyone, if you look at the videos that were shown at trial, almost everyone was carrying a weapon that night, including one of the individuals that he shot, who was actually illegally carrying a gun, whose testimony I didn't find very compelling at all. So when it comes to Gage Groskowitz, he was illegally carrying a handgun that he had lost the right to carry because of a criminal charge against him. Here's the thing. I also don't love the, kind of the demonization of those that were shot, and again, uh, they were found to be the provokers of this, but there's still people who were shot and injured or shot and killed. So for me, if I say victim, I'm still gonna say victim because still shot and killed. But the kind of demonization of them as well based on their criminal records, it's gotten very interesting to me. Look, um, they had, well, particularly with regard to Rosenbaum, had a horrific criminal record. However, at the time that this happened, one, Kyle Rittenhouse didn't know that, and two, that's to be dealt with in the court system. I don't want to see us getting back to a place where it's like, oh, well, you've been accused of doing this, so now it's okay to kill you, because that's never okay. So that also is hard for me watching, like, Kyle's a hero and these guys are this, and it's like, no, this is a bad situation for everyone. Um, this is a bad situation for everyone involved and shouldn't have been and was. And that's really how I see it, and that's my perspective. I don't know. Bringing up the criminal records, I understand is full and fair to get a full picture of everything and should be done, but it's not a reason why it's okay, because it doesn't make it okay. So, yep, a tired millennial said, their records are irrelevant to the facts. Yep. We can't say it's okay to kill someone if they later turn out to be an awful person. Exactly. Thank you, a tired millennial, for being more articulate about it than I am. So I think it's just I think it's gotten very heavily polarized. And I think what we need to focus on is a better understanding of what the laws are, jurisdiction by jurisdiction. Because for people from states that don't have open carry laws, all of this seems very strange. And I think understanding the facts is really the most helpful. And that's not what's been happening. So that's where my frustration with the whole case was, but also the demonizing and heroizing of those in this case also doesn't sit well with me. So all of it is tragic. All of it is tragic. So that's where I'm at with that. And we're going to continue on with the tragic and talk a little bit about the McMichaels case. So let's get there real fast. And where are we at? Whoa. Oh my goodness. How are we 19 minutes in? Before we get to the McMichaels case, I need to share something else with you that I hope that you very much enjoy. And I hope you can very much hear. So let me share something with you real quick before we move on. Why is my screen not shared? Because we're professionals here. Because of course we are. Because because of course we are. So let me share this with you real quick. A huge thank you to today's sponsor, Eggcorn TV. If you haven't heard of Eggcorn TV, you are absolutely missing out, and you're going to be like, girl, thank you. Eggcorn TV is your like a one-stop shop for Brit TV. It's so fantastic. Ad free. It's only $5.99 a month. I've got a code so you can try it free. So you're going to get to see how great it is. I first heard of Acorn TV when my mom was looking for a way to watch her favorite British miniseries and couldn't find them anywhere. Acorn TV is the solution. All your favorite shows, they even have them like divided by section when you go through the website, including the cozy mystery section. There is plenty of Brit true crime, lots of originals, movies, miniseries, television series based on true life, period pieces. No one does a period piece like Brits. And it's so easy to binge watch because it is truly an ad free experience. And you can watch it on your phone, your computer, your tablet, your Chromecast, your Apple TV, Amazon Fire TV, Roku, anywhere that you want to watch, you can. And right now, there is plenty of time to binge watch Manhunt the Night Stalker. So, for all of my true crime law nerds out there, the Night Stalker just finished this season. The New York Times said that Martin Clunes is excellent in a crisp, moving drama. This series is based on the real life diaries of the London Metropolitan Police Detective DCI Colin Sutton in their pursuit of the notorious Night Stalker, whose 17-year reign of terror left thousands living in fear. And when this detective came onto the case, ended or solved the case in short shift. So you're going to have to go check it out. With Eggcorn TV, there's always something new to discover. Try Eggcorn TV free for 30 days with code Emily D. Remember, the codes need to be in the little ones, not the caps, in the lowercase. It is case sensitive. So go to Eggcorn TV, use promo code Emily D, and let me know on social what show you are loving. You guys, they have Law and Order UK. Law and Order UK has Freema in it. I fell in love with her in Doctor Who. It's so great to find her in other series. And Law and Order UK is just, I'm living. I'm just living. It's a great twist on the typical American series. So go check it out. Let me know what shows you're watching so we can chat about our favorite TV. Look, it's cozy season. It's time to stay in and watch a little TV. So Acorn TV, promo code Emily D. I know you're going to love it. Let's get back to the legal stuff that we're talking about. We should just do that. Let's get back to it. As I tried to swoop it back and didn't. Thank you all. And thank you again to Acorn TV for sponsoring the channel, for giving us a free 30-day trial. I'm very excited. So thank you all. It allows me to keep these videos with less ads and bring you all of the stuff, So I saw a few more questions about the Rittenhouse case, and I will get to them when we get to Q&A, because we are swooping to move on. And I did say I was going to move on to the McMichaels case. I should timestamp that for sure, because that's helpful. With the McMichaels case, and it always sits weird with me calling a case, like in the media, the name of the victim, especially in a homicide case. It's strange to me. And it happens sometimes. Sometimes, like the Rittenhouse case, the media refers to it as the Rittenhouse case. Kyle's the defendant. He was the one that was charged. He was the one on trial. But in the McMichaels case, it's generally referred to by the name of the victim, Ahmaud Arbery. But he was the one who was killed. So it's weird to me when and how that choice is made in the media. I've never worked in the media. I don't know. But the McMichaels are on trial for the killing of Ahmaud Arbery. In the evidence that I have watched and covered and looked at, and in the prosecutor's arguments, I think that though they are trying to go for a self-defense claim, the McMichaels defendants are trying to get to the point where they can show that they were making a lawful citizen's arrest, so they had the right to attempt to detain Ahmaud Arbery. If there was not a lawful citizen's arrest, which is generally my opinion, if there was not a lawful, under Georgia law at the time, citizen's arrest, then they didn't have any reason or cause to try to detain Ahmaud Arbery. So he was in the right to fight back. Therefore, they were the aggressor. He tried to get their weapon away from them because, They had a weapon with them. He was fighting back against them and was shot by them in that. But they don't have a right to self-defense if they're not in the right trying to detain him. And that is a lot for a jury to parse through because, again, self-defense in that case is predicated on whether they were legally at the position where they could detain Ahmaud Arbery, not their belief, but whether they were legally right in doing so. If they were not legally able to do that, then they are the aggressors. Ahmaud Arbery had the right to use self-defense to try to dissuade them from abducting him. And and in that, him getting killed is then a felony homicide because they didn't have the right to use force against him. He had the right to use force against them. So it is not a I don't know. It is not a legally cut and dry case, though I think, again, the facts are very much towards a conviction. I think the facts as they've come out would support a conviction. I would be very, very confused if this came back uh, with not guilties. I would be confused by that. So we I have not covered it a ton because I was covering and watching the Rittenhouse case and everything else that has been going on here. The legal positioning of this case has a little more quirks than just the facts of this case. I'm very interested to see what the jury does. They are still deliberating. Tomorrow's Thanksgiving, so it's amazing how jurors tend to resolve their disagreements on the eve of a holiday. I won't be surprised if the jury comes back today. They have a lot to parse through. There are 3 defendants. I didn't think this would be a super quick verdict. I think a jury, especially in a high profile case, especially in a case that is somewhat polarized, there's protests outside the courtroom and some marches in support that aren't protests. I think that a jury is mindful of that and wants to take their time and discuss everything. I know for a lot of us, I wouldn't feel good about that if I was a juror and I didn't go through every single thing. Like it shouldn't just be a knee-jerk reaction. I feel they did this, I feel through they did that. I would want to go through each jury instruction. I would want to talk through the facts. I'd want to hash everything out. And I think that's what this jury's doing based on the fact that they spent most of the day yesterday deliberating. I think the prosecution in this case has been excellent. I think they've made very good points. I know people have been put off by the way the defense has argued. Look, the defense's job is to argue vigorously on behalf of their client, and they have done that. I just don't always agree with the way that they've done that. But it's really interesting when you are an attorney and then you watch other attorneys, you're like, oh, I wouldn't have done that way. Oh, I wouldn't have done it that way. Oh, I understand why you're doing it, but I still don't like it. And that's where we're at. So I think we will see a jury verdict on that today. So that's where it is. It's interesting to note that the law in Georgia has already changed after this killing, in that the self-defense law that was in place has now been I don't remember if they repealed it or determined it to be unconstitutional, but I have a problem with citizens arrest laws anyway. I don't love them. I don't love um giving average citizens kind of the color of law enforcement without the training. I think our regular law enforcement should have more training as it is. Um, and telling citizens, yeah, you can go ahead and do that. No, no, that's not what I want to see happen. I have problems with other laws that do that as well. Let's not deputize people to enforce the government's duties. Like let's just not. Let's just not. Charlene asked, you said self-defense. Did you mean citizen's arrest? No, Charlene, I meant self-defense because the citizen's arrest, with the legal theory of the case, the citizen's arrest, if the McMichaels are making a valid citizen's arrest, which is no longer a law in Georgia, but was, if they're making a valid citizen's arrest, then they have a reason to try to detain Ahmaud Arbery. If they have a reason to try to detain him and he starts fighting back with them, then they can use force against him in self-defense. If they are not in a legal position to try to detain him, then he has every right to fight back against them, because then they're not trying to detain him. In his mind, they're trying to abduct him. and they don't have a right to do that, then he has a right to use force against them. They don't have a right to use force back against him because they're not in a place to use self-defense because they've provoked it. So, oh, I said they repealed the self-defense law. Thank you. No, they repealed the citizens arrest law. Appreciate it. So we will see. We will see what happens. I think that they are wrong on the law, and the defense attorneys learned that they were wrong on the law. Even if they're convicted, it is going to be appealed. There is going to be a lot more that happens. But I do think, just based on everything I've watched, I do think that they will be convicted. If the jury takes much longer, we might start leaning towards an undecided jury or a hung jury. But for now, I think the facts lean towards guilt. So we will see. We will see what happens with that jury. And I will update it on social media. If you follow me on social media, I am at the Emily D. Baker. I will update it when that happens. If that happens, there are other law tubers covering it. I know that Nate the lawyer is watching it live. I believe Legal Bites has been watching the verdicts. I know that Viva Fry is. So you can pick your flavor of law tuber and watch somebody waiting for the verdict, because that is going on all across the interwebs. Not me today. So Larissa said, is it typical for attorneys to learn new info during trial? From witnesses, it can happen, especially in criminal trials. They don't do depositions and as much work before they do. But with regard to their understanding of the law, no, they should have a pretty solid understanding of that before the trial starts, which was interesting to me. So Chelsea, hello from Waukesha, Wisconsin. I am listening live while working. Know that the Law Nerds thoughts are with your community. We are all just like, seriously, what the fuck? It's awful. I don't know how I would process that. I moved to Nashville not that long before the Nashville bombing and felt gutted over it. But I came from a much smaller community than that before we moved, and I would be absolutely devastated. So our thoughts are with you, and thank you for popping in and saying hello. All right, we are going to move on to one. God, this is not a true crime show. It's not. But that's what's happening in the world right now. Crime is happening in the world right now, and we're going to talk about Brian Laundrie real quick, because this is news, and there's more news that I was interested in other than what we've heard before. So I'm going to pull that up. I'm going to swoop it. I'm going to give a quick warning as we swoop to this topic. Warning. I posted on social media the suicide hotline. I will post it down below. Warning. That's what we're talking about. It is always hard for me to talk about. I have lost too many people in my life to suicide. It's hard to cover. It's hard to cover. It's hard to talk about. It's hard. And for anyone whose life has been touched by loss in that way, you understand exactly what I mean. And I hope that most of you have not had to have that experience. It's not a good experience. It's just not a good experience to suffer loss in that way. So I will be posting the suicide prevention hotline down below. And look, there is always another option. There's always someone to talk to. When it comes to Brian Laundrie, I can appreciate that he probably felt that there was no other option. But let's talk about the coroner's report. I'm just going to pull up their report first, and then we're going to talk about some new information that we learned from the statements of the lawyers. It's always the lawyers right now. Lots of lawyer talk, and we're going to pull that up. So let's go through what the press release from the coroner or the medical examiner said. Sometimes, the ME is the coroner. I'm going to try to make this a little bit bigger. And this is a press release from yesterday from the District 12 medical examiner. With regard to the death of Brian C. Laundrie, the District 12 medical examiner completed our investigation. The investigation included the following. I appreciate that they gave us this information. Scene response by medical examiner personnel, complete examination of the recovered skeletal remains, consultation with a forensic odontologist including dental comparison for identification, which means that the person who did the dental comparison, there had been rumors um, that the person who did the dental comparison was somehow related to Brian. While his uncle, and I don't know if his uncle is a dentist, maybe a dentist, um, if if his uncle is his dentist, he would have provided the records, but he wouldn't have done the comparison. And this just clarifies that for us that, again, the records could have been provided by his dentist, the person who had been his dentist, the x-rays and what have you, but it would have been compared by someone else. And we're learning that in this report that the forensic odontologist, I hope I pronounced it right, did the dental comparison. Consultation with the forensic anthropologist, including skeletal reconstruction. And that's probably where they confirmed, I would imagine, that's where they would confirm the cause of death and manner of death. Confirmation of the identity of the remains by both dental comparison and DNA analysis. So this has been taken care of with DNA analysis as well. There had been a lot of speculation about whether or not there would be DNA, about whether or not there would be more than just the dental comparison, even though a dental analysis is a actual proper and reliable terms of identification. But they also did a DNA analysis, and now we know again for sure that this is Brian Laundrie. The cause of death has been determined to be a gunshot wound to the head. The manner of death has been determined to be suicide, so a self-inflicted gunshot wound. Complete signed records are going to be on file. The questions that remain for me, and then we'll get into what the families have said, but the questions that remain for me are, was a weapon recovered in the park? Because it, because there would have been a weapon there at some point, because it is a gunshot wound to the head. So was a weapon recovered, or is there a gun floating around in that park somewhere, which would be odd. So I don't know if they recovered that or not. We might not know that for a while. It could have been recovered and they didn't share that information with the public. They have the right to do so. So I don't know. The family statement of Brian Laundrie's parents' attorney, the Bartolino, indicated that the family did own it. Well, let's just pull up the news report from WFLA and go through it real quick because there's more information in there. So the where is the Stephen Bertolino statement? Stephen Bertolino, the Laundrie family attorney, texted WFLA reporters. This guy is constantly just like, hey, what's up? Here's my statement. It's okay. Cool. Go ahead. Text your statement in. Great. It just seems odd to me. Maybe it's not odd. It seems odd to me. Texted WFLA reporters about the findings of the autopsy early Tuesday before they were officially released. So he gave them the heads up that this information was coming. The Laundrie parents would have been given this information. I hope that the Petito parents were given this information as well ahead of a press release. Generally, law enforcement tries to notify families of stuff that is coming out before that is publicly released. Chris and Roberta Laundrie have been informed that the cause of death was a gunshot wound to the head and the manner of death was suicide. Bertolino said Chris and Roberta are still mourning the loss of their son and are hopeful these findings will bring closure to both families. There's still more questions. They also, where's the rest of his statement? I will have to go to Twitter to get the rest of the statement. The Petito family released a statement through their attorney who said Gabby's family will not be making a statement at this time due to the request of the United States Attorney's Office and the Teton County Prosecutor's Office. The family was asked not to make any comments and let the FBI continue their investigation. The family was also asked to wait for the U.S. Attorney's Office to make a determination on whether any additional individuals will be charged. When that determination is made, we will have a statement. That is very, very interesting information. That statement, though short, has quite a lot of new information for us, which means that the U.S. Attorney's Office is at least contemplating charging someone else, additional individuals. Additional individuals reads to me, and again, this is their family attorney choosing these words, but additional individuals reads to me as if they, the U.S. Attorney's Office or the FBI, someone has made a determination that, again, even though Brian Laundrie was only listed as a person of interest and not a suspect, that he is their primary suspect. Are, all of us are, I think, in that train of thought that this was not a random homicide, that this was a relational homicide. The coroner made that statement in the Gabby Petito case. It seems that Brian Laundrie was the last person to see her alive, and then the ending of his own life seems to all lean towards that is what happened. But when they say any additional individuals being charged, I don't know if there are questions about his parents and whether his parents could be charged as, accessories after the fact in this case. So it's interesting that that was said. It's interesting that that was released. And I'm very, very curious to see what determination is made from here. The FBI has not closed this case. The case with Brian Laundrie using Gabby Petito's debit card to access her bank account, withdraw money, has not been closed. It has not been dismissed with prejudice. It remains open. So even though they would have had a death certificate already, I imagine, it's very interesting that that case has not been closed. Now that could still come, and I will be keeping an eye on it for when that happens and let you know. But the FBI has not closed this case, and they will make a statement when they do, or they will make a charging statement. So this is very much still an open investigation into the murder of Gabby Petito, even though Brian Laundrie is dead. And from other statements that were released, because this doesn't seem to be the full statement that was released on Twitter. Let me pull up the full statement from our news source du jour, Twitter, because look, the information's on the Twitter. So we're going to the Twitter. I'm going to JB. I can't pronounce JB. Hey, JB's last name. Sorry, JB. I can't. But we are going to go through your sharing of this statement on the tweet on the street. It's always 20 plus notifications, by the way. Always. Let's see. Where is it? That's the medical examiners. That is their stream. Let's see. Hearing the FBI is preparing a release. Well, we will see if the FBI releases anything today. I was looking for the Bertolino, whether remains will come. I asked Laundrie family attorney Stephen Bertolino whether the update on the examination will come from him or from law enforcement. He believes both. The final autopsy results could be announced. But he had said, Bertolino had said that the family did have a gun and a gun was missing from the family home. I'm just trying to see where that is. It might have been on Brian Enton's Twitter. The reason that matters to me is that if that's the case, it doesn't seem that it was conveyed to law enforcement, but it could have been. But the way that law enforcement continued to call the search for Brian Laundrie a search didn't make me believe they were doing a recovery. If the family had told law enforcement that he not only went hiking, but he went hiking with a missing firearm, I think that would have changed the way that law enforcement would have responded to that search. And it would have not been a search and rescue operation, but a recovery operation. And it is from Brian Enton's Twitter, who is a reporter, not with WFLA, but I think News Nation. It's probably in his Twitter. Yeah, News Nation, based in Miami. When Brian Laundrie was reported missing, his parents turned over all of their firearms, but one was missing. This is according to the Laundrie family attorney, Stephen Bertolino. Well, if one was missing, That's information that law enforcement would have wanted to know if they were searching for someone who was armed versus searching for someone who was unarmed versus searching for someone who might have taken their own life. It changes things for them. And that could also be an issue that that they did not tell law enforcement. If they did not tell law enforcement doesn't tell everything to the public. So it will be very interesting to see what happens. Yep. Very interesting to see what happens. Do I think charges will necessarily come for Brian Laundrie's parents? I don't have enough information to make that determination, though I'm sure you want to know. I want to know too. But we're going to have to wait a little bit more on that, unfortunately, because they're not done yet. So we'll see. You guys ready to move on to pop culture? I'm so ready to move on to pop culture. Just if you are new to the live stream, pop a 1 in the chat and don't forget to subscribe. And if you are not new and you're ready to move on to pop culture, just pick an emoji and put it in the chat. We'll emoji it. We're gonna fluff our aura. Wait, is like Whitney from Real Housewives of Salt Lake City, because we're going to Salt Lake City next because it's criminally adjacent. So let's fluff our auras together and move on to Stuart Smith. It's time to move on. It's time to move on. You all are like, yes, it's time to move on. It's time. So, Stuart Smith's change of plea. Let's talk about it real quick. And then after Stuart Smith, we're going to get real quick to the 2 Britney documents and to H3 and then to Q&A. So, yes. All right. Stuart Smith's change of plea. We knew this was coming. I mean, back in July, August, I should actually just pull up the document, which I didn't do. I should just pull it up. It's July, August. Stuart Smith's attorney said that they did not need a new sentencing date. They did not need to be at the pretrial conference because they anticipated a change of plea. Let me just pull that up real fast as I am chatting. So if you see me looking that way, that's where my documents are. That's why. But didn't need the pretrial conference because they were anticipating a change of plea all the way back. I think it was August, right around there, July, August. So we're going to pull it up real quick. But with that, it was, pretty clear that they were trying to work out a plea. The day that this arrest went down, I was in Clubhouse with Dave Quinn and Kate Casey and others talking about the fact that if I were the lawyer for Stuart Smith, based on my watching of Real Housewives of Salt Lake City, the first thing I would do is call the U.S. attorneys and say, hi, we represent Stuart Smith. We'd like to tell you what we know. Would you like to know what we know? We would like to work out a plea deal with you. Thanks. Okay, bye. That would be the first thing that I would do. Let's pull this document up. This is the document that kind of sealed it for me, though it was always my take on this case that Stuart Smith would tell the government what he knows to save his own ass, which is exactly what happened. So for those of you that are like, who, what, huh? Stuart Smith is Jen Shah's first assistant. He plays fairly heavily into her aspects of the show. And she has him drive her around and carry her bag. And there are scenes this season of him on the computer. And she's like, make me money. Aren't I the best boss? That is all going to bite her in the ass when this goes to trial, if this goes to trial. So this is from Stuart Smith's attorney, Gilbert Attache, something like that. Dear Judge Stein, August 4th. Dear Judge Stein, I represent Stuart Smith, assistant number 1. In the above referenced case, in response to the court's order of August 3rd, setting a pretrial conference on August 10th at 2 p.m. to establish firm dates for trial, I represent to Your Honor that Mr. Smith is working diligently towards a resolution of his case. Plea deal. I am confident his case will be resolved without the necessity of a trial, and I hereby request that we be excused from the August 10th hearing. Your Honor, we're just trying to tell the government everything we know and change our plea. Thanks. We'd like to go away. We would like to tell you what we know about Jen Shah. And that seems to be exactly what has happened. Because on Friday, while I was on a plane, there was a hearing and Stuart Smith changed his plea. In the course of him changing his plea, there was also a new charging document filed. Let me pull that up real quick. So the superseding indictment was filed, adding a new count, as does Stuart Smith. His maximum potential exposure, meaning the max time he could spend in custody, is now 70 years on 3 counts. We only had 2 counts before the 2 he was charged with in connection or as a co-defendant with Jen Shah. So Stuart Smith is now charged in count 1, conspiracy to commit wire fraud. Again, he's charged as a co-defendant to Jen Shah. Count 2, conspiracy to commit money laundering. And I go through this indictment in other videos, and I've chatted about it on multiple podcasts. It's all the Emily OPP. I have a whole section here with a playlist of where I've been on other people's platforms, also on other people's podcasts that you can find on that playlist. That's why I call it OPP, other people's platforms. Count 2, conspiracy to commit money laundering, and a new count 3, obstruction of an official proceeding. This is your typical kind of obstruction of justice. In or about June 2018 in the Southern District of New York and elsewhere, Stuart Smith corruptly did and attempted to obstruct, influence, impede an official proceeding. To wit, Smith made materially false statements during a deposition conducted by the FTC. We have gone over that FTC proceeding, and we have gone over the parts of the deposition that have been submitted by Jen Shah's attorney. The government is alleging that the statements made, or at least some statements made in that FTC deposition by Stuart Smith, were false. And that 2018 deposition came after the 2017 FTC case brought against Stuart Smith, Jen Shah, and their companies in relation to this scheme. So they had a heads up. When Jen started filming, she knew that the FTC had already come for her. She knew that co-defendants in this case had already been raided by the FBI and arrested. Look, she was aware that this could go down. So I don't know. I don't think she was as caught off guard as other housewives when they get up to when stuff comes for them, because again, this is the first housewife where she's being charged on her own behavior, not being charged for someone else's behavior. So Stuart Smith took a factual based plea or gave a proffer, depending on what court you are, they call it different things, where he said, yes, I did this, I did that, I admit to this, I admit to that, and stated that he knew that the marketing services they were selling had no value, stated that he knew that the people that were their victims were over 55 years old and there were more than 10 of them. So admitted to the different parts of this indictment for the purpose of them being able to take the stand. Stuart Smith has now changed their plea to guilty. There is no Fifth Amendment right attached any longer. There's no longer a right against self-incrimination. There's nothing else to incriminate against. You've already pled guilty. So he can testify at trial against Jen Shah. And that's exactly what I think is going to happen if this goes to trial in March, is that Stuart Smith is going to testify against her. That's what I see coming. Unfortunately, because this is a federal case, the trial will not be televised. However, I am very tempted to just go to New York and go. I am very tempted to just go. Very tempted. We will see. We will see. I am tempted. Bravo. I'll be your trial correspondent. Call me. I'm very tempted. So, with Stuart Smith testifying against her, this case is going to get very much more difficult for Jen Shah. I wonder if cameras were rolling when she found out that he was going to now be testifying against her, because that's why you take a plea like this. They take the plea. So this is what happens for Stuart Smith. He takes the plea. He gives the factual information. He can now take the stand against Jen Shah. He will not be sentenced until after he testifies in her trial. The sentences keep getting put over. There are other defendants that have pled. Their sentencing dates keep getting put over until they testify against this trial. So none of them are going to get sentenced until this trial winds up as to Jen Shah, if she goes to trial. Jen Shah can still work into court and say, Your Honor, I just want to plead guilty. Like, I don't think she's inclined to do that, but she still could. So we'll see what happens. There's a long way to go between now and March. I mean, it doesn't feel that way for us like living in real time, but in court time, there's a lot that can happen. And I'm going to be following along with it. I've been following this since the day Jen Shah got arrested when I was freaking out on Clubhouse and Twitter going, holy shit, it's going down. I'm yelling timber. Yeah, freaking out. And then when we heard production was filming, like, I can't. I can't. I can't. So the Jen Shah of it all is going to be very interesting. I know. And we've got other trials that are in federal courtrooms that I want to very much see. We will see about the Maxwell trial. I have not decided if I'm going to be covering that, but the Theranos trial is still going on and we're getting into the defense case. So there is lots to cover. Some of it's going to go into the podcast because not all of it's going to go into a live stream. Y'all ready to move on to Britney? I'm ready to move on to Britney. We're going to just talk about the new documents that have been filed real quick, and then we're going to move on to H3. Put a 1 in the chat if you're more excited for Britney, and a 2 in the chat if you're more excited for the Triller-y-ness of it all. And you can drop a 3 if you're like, I just want all of it. I want all of it. All of it. All of it. As I pull this up. All right. Let me timestamp and swoop myself. And we will move on. And we will move on. I can't believe there are still new documents being filed in the Britney Spears case, but there are. Sure are new things being filed in the Britney Spears conservatorship. These are joint objections from Jody Montgomery and John Zabel. This was filed on November 18th, but again, traveling. So we're getting to it today. Look, sometimes you have to do the family things. And so streaming comes sometimes second to the family things. I know. What YouTuber says that? It's a crazy, crazy world we live in where we're like, oh, we need to have real life time. We need to have real life, not on the internet family time. And you know what? Even though travel during the holidays is miserable, it was really nice to see everybody. So let us get to this joint objection. I left my purse in the other room. You know what that means? It means I have no lip gloss. Oh, I'm so mad. Oh, I've got this one. I've got a backup lip gloss. We needed more lip gloss. But I left my favorites in my purse in the other room because, our brains aren't back from vacation yet. Well, it wasn't really a vacation. It was a trip. You know what I mean? All right. Let's get to, y'all know what I mean. Trip versus vacation. It's a thing. All right. Joint objections from Jody Montgomery and John Zabel to James Spears' proposed order. This is not to terminating the conservatorship. This is just an objection to the proposed order. The wording of the order, they are calling it fuckery. So let us get into what they're saying the wording is and what fuckery that wording has, because that's what's being alleged. John Zabel, former temporary conservator of the estate of Britney Spears, and Jody Montgomery as former temporary conservator of the person, jointly present their objections to the incorrect, grossly misleading, and procedurally improper proposed order submitted by James P. Spears on November 17th, 2021, in violation of California Rule of Court 3-1312, and alleges as follows. Now, here's what happened procedurally. Here's what happened. James Spears filed the motion to terminate the conservatorship. That motion was granted. So it was James's motion that was granted to terminate the conservatorship. So James Spears filed the order. Look, be mindful in your legal practice who you let file the orders, because they can write orders that aren't exactly the way that you see things or exactly what the court ordered. That matters. So let's see what they're saying James Spears' order said and why they have objection to it. The proposed order submitted by James Spears is misleading and inaccurate. Rather than accurately reflect the orders made by the court on November 12th, James Spears has submitted a proposed order riddled with misstatements. Oh, the fuckery. The conservatorship has indeed been terminated, and the limited administrative conditions subsequent, which Mr. Spears references, were clearly articulated at the hearing such that any reasonable person present at the hearing would understand the limited issues that were left to wrap up. Oh, Mr. Spears, what did you do? What did you do? Mr. Spears, the disgraced, suspended former conservator who continues to improperly seek to bolster his reputation at his daughter's expense, has shown that he is not such a reasonable person. Oh, the shade. He's yeeted. He's been yeeted, but he will not allow the yeeting to continue. He's like, I've been yeeted, but I will not go. I will not go. I don't know. It reminds me of that scene in Empire Records where they're like pulling the shoplifter kid who ends up working there at the end, spoilers, out, and he's like, my name's not Warren. It's like he just won't go. Like, these are death rattles on death rattles of James Spears going, you can't make me. I'm very important. Ugh, yeeted Spears, stop. The conservatorship has been terminated and Mr. Zabel has retained limited administrative powers that will be completed shortly. Yes. That's what the minute order said. It became apparent after Mr. Spears's ignominy. I hate this. I love this word. I hate trying to pronounce this word. Ignominious, but necessary and appropriate suspension of the toxic conservatorship he corrupted. I feel like, okay, who filed this? Let's see. Lori Ann Wright. Lori Ann Wright. Doesn't it feel good to just let the sass fly? I feel like Rosengart has empowered everyone to just step up and say what they mean with some sassy words. I feel like he's empowered some more sass. So let us continue with the Lori Ann Wright sass we're living. We love some good lawyer sass. Toxic conservatorship. He corrupted. Wow, it's just all of it. All of it. Because of one, his dilatory and disorganized production of files, which failed to include his communications concealing the alleged A, contemporaneous real-time eavesdropping on phones used by Miss Spears via iCloud mirroring of those phones, and B, placing an illicit listening device in Miss Spears's bedroom to capture intimate communications, including the failure to produce his communications with counsel as required under the Mueller and Stein cases. Wow, Dad Spears just isn't turning over his files, which is making shit more difficult. Who could have seen that coming? All of us. All of us. And 2, a term of the prior trust requiring court approval for an amendment. Limited additional time was needed for the completion of administrative matters. Oh, so the reason it's not done yet is because Dad Spears hasn't turned his shit over. Shocked Pikachu face. I'm so surprised. Dad Spears hasn't turned over his shit. Weird. Consequently, at the hearing, it was ordered that Mr. Zabel would retain power, 1, to maintain the pending petition for substituted judgment that had been filed before the hearing and is currently set to be heard on December 8th, and 2, to transfer the former conservatorship assets, Britney's assets that are in a conservatorship estate, to a new trust, not the old trust, a new trust. These powers were also necessary because Mr. Spears had planted. He like a grenade, like a ticking time bomb. He planted like a flaw in the Death Star in the trust estate. Does that make Rosengart Luke? Who's Luke in that analogy? Hold on. Okay. We're going back. We got to get back to this. All right. Plan to determine Miss Spears's prior estate planning documents, which would have kept her unnecessarily tethered to the court in order to make basic estate planning changes for herself. I know this has come up elsewhere, but yes, the estate planning documents are finally being reviewed because people finally have them. And now they're able to see what Spears did to keep the estate planning documents tied to the court so that he would have, this is my speculation and perspective. This is not what this says. It's my speculation and perspective that that this would keep him in the loop no matter what happens, because it would still go through the court and he'd still be able to see, which is probably why it's being so strongly fought for, to keep all of the subsequent plans confidential, not just for HIPAA privacy and medical privacy, but to keep the subsequent care plans private from Yeated Spears, because we already see him putting in these little things, these little barbs to try to continue to retain some level of control. All right, let's keep going. Despite the fact that these limited administrative powers were expressly identified on the record in open court on November 12th, Mr. Spears, Yeated Spears, falsely and nefariously suggests that there are other conditions subsequent. But that's so fucking shady. Oh, no. Despite Yeated Spears' unsuccessful efforts to avoid his... Stop it! Only once per document. It's like continuing to say nutraceutical over and over. It just makes life hard for me. Ignominious September 29th, 2021 suspension after his prior efforts to prolong the conservatorship for many years until his sudden self-serving 180-degree reversal on September 7th that was actually designed to avoid his suspension and comply with discovery. The conservatorship has, of course, been terminated. No care plan was either ordered or suggested to be filed, and indeed there is no need for such a, quote, care plan since the conservatorship of the person has already been terminated. Oh. The proposed order submitted by Yeated Spears inaccurately states, we get to the order. Yay. Subject to conditions subsequent, meaning after, later conditions, regarding the transition and future care plan for conservatee Britney Jean Spears that are subject of the papers to be filed by John Zabel as temporary conservator of the estate and Jody Montgomery as conservator of the person. Temporary conservator of the person. The termination petition of James P. Spears is granted. So they're adding in conditions subsequent and leaving it very vague regarding the transition and future care plan. The only condition subsequent was the time where Zabel retained power to transfer estate assets. That was it. And it was very limited. And it's spelled out in the minute. We should pull the minute order. Let's just pull out the minute order. Where is the minute order? Let's pull up the minute order, which is still on my Twitter with a link that is working most of the time. If you want your own, let's pull up the minute order and just look. The court finds evidence has been provided to grant the matter on calendar, terminate the conservatorship is granted, determines that the conservatorship of the person in estate is no longer required and terminated, with the caveat that John Zabel, as a follow-up and conclusion of his services, is to complete the following: file a subsequent judgment, which has been filed with the court this date, and shall be assigned a December 8th hearing. John Zabel is ordered to transfer assets into the trust. That is the condition subsequent. Transfer assets into the trust. That is it. Transfer the assets. That's it. That's it. That's it. That's all. It's right here in the minute order. The November 12th minute order makes it clear. That's what was said in court. That's what's in the minute order. Transfer the assets. That says nothing about a care plan. That says nothing about a vague transition. It says transfer the assets into the trust. And that could have been said here and it's not. Okay, let's go into why they find the sentence incorrect for numerous reasons, because the shade hopefully will continue to be delicious. This sentence is incorrect for numerous reasons. First, as explained above, and as the record demonstrates, there is no condition concerning a care plan. Accurate. Rather, the conditions subsequent are administrative only and concern the petition for substituted judgment and estate planning. Accurate. Second, there is no future care plan. No such document exists. Third, as a minor point, but Miss Montgomery was the temporary conservator of the person. I said that too. I should have just kept reading. Keep reading, Emily, and it'll say what you're saying in your brain. Other inaccuracies. Ooh, it gets a whole heading. Other inaccuracies. The proposed order is replete with other inaccuracies requiring correction. Replete is a great word. I loves it. Page 1, line 8 should read, former and now suspended. You've titled yourself wrong, Yeeted Spears. What you should have titled yourself is not former co-conservator, but former now suspended co-conservator. That's what you should have said. Let's be accurate. Former and now suspended co-conservator for accuracy and completeness. Page 1, lines 21 through 22, item 2 must be stricken as inaccurate. The court made no such finding that Mr. Spears' self-serving petition was true and correct. He put it in there. The court didn't say true and correct in their ruling. To the contrary, his petition contained many falsehoods. Page 1 should did they attach it? Hold on. I just want to see if they attached it. Damn it. I don't have it. I don't think I saw it on the court website. Okay, I squirreled. Give me a second. We're all going to squirrel together and see if we can find it. I didn't see it. But it might be there. And I'll look on Twitter real quick as well, because now I want to see what it says. But I was busy reading the H3 transcript last night and didn't go looking for it. So let's see if we can just grab it real quick. Let's see. We're looking. It takes a minute. The LA court website is one of the more difficult. It's like layers and layers and layers and layers and layers. We've got the objection to the proposed order. Wait, that's a new one. That's from, hold on. Where did that come from? Why are there new things? Okay, let me see. I grabbed 2 yesterday. This looks like a new document that I have not grabbed yet. And we will, let's see. Where is it? Where's what I grabbed yesterday? The amount of documents to keep straight is not always my happy place. This is not it. What we pulled yesterday, or what I pulled yesterday, was objection to the proposed order and notice of hearing. There's a new objection to the proposed order. Well, we have breaking news. I'm going to update the title of this. We have a new motion that just popped up on the court website. So that's fun. The Dummies 05 said that was filed by Britney. Well, good. Now we have another petition that we're going to go through in just a moment. Let me see if I can find the actual... I don't see it. I only see the minute orders. I don't see, and I still don't have it. The order, the proposed order is not here. So we can't pull the proposed order, but we can pull the new order. Let's do that. New. All right, we're going to let this send to me, and we're going to be like exclusive. I should actually tweet that out, but I'm not going to, because I'm going to finish pulling up this order. Somebody's welcome to share it that there's a new order. New order. No. All right, let's do it. This is why we look. All right, good. Email me the document. That should be there in a minute. I'm going to just share this out real quick, and then we'll continue with our regularly scheduled program. There was stuff filed under seal, but I don't think it was the proposed order that was filed under seal. I didn't see that. So, yep. Oh, wait, I wanted to answer that. Is it possible that Spears is not turning over records because he took a lot more money from the estate than what was reported to the court? I mean, that's always a possible reason, but can't do that. There's always a possible reason. Could it be that Dad Spears is trying to hide information and that's why he's not turning over things? Yes. Yes, that's possible. Yes. Yes, yes. Yes, yes, yes. All right, let me share this. Um, new. New. Let's see who filed that. Let's see if I can actually say who filed that before. Yep, Britney filed it. We knew that. Um, Britney, Britney objects to her dad's fuckery. All right. Let's see if, well, now at least people know there's more new shit. Let me save this so I can pull it up on screen. And yeah, this was filed yesterday at 7:20 p.m. Pacific. So I'm not surprised this just populated on the court's website. We love it when we find new shit while we're live. The bots are like, no, we don't though. We don't though. Uh, all right. Rosengart's objection. Let us pull it up and then we'll get back to finishing this objection and then we'll do the new, then we'll get on that new shit. Sorry, my head, look, the more tired I am, the worse the like songs in the brain get. It's just, is anyone else that way? Oh, I've lost my place. Y'all are like, we're watching it real time. Yes, normally we have very smooth live streams, but today we have too much to talk about to have a super smooth A's live stream. Let's upload this and let us, yay, there it is. All right, we're going to finish this one, then we're going to get to that one. Great. Jody Montgomery's isn't done yet. Let's continue on with the inaccuracies and shade, and then we'll get to the new one. That sounds like a plan to me. Sounds like a plan to me. All right, y'all. I mean, it really is a good squirrel moment. And I tend to try to follow my gut. When my gut's like, you should look at this, I normally need to look at it. And it normally proves to be for a reason. There's the chat. We shouldn't have pulled well, yeah, that's what I was pulling up. There's the chat so I can see it in the background because um when it when it when it slows down on StreamYard, then I can have it. Let's pull up this document. That's what I meant to be pulling up. And let's go. Other inaccuracies. Page 1, lines 21 through 22, item 2 must be stricken as inaccurate. The court made no such finding that Mr. Spears' self-serving petition was true and correct. To the contrary, his petition contained many falsehoods. Oh, he's trying it in this order. He's trying it. The Aubery, what is happening? Okay, let me look. Yes, we'll do it. Of course we will. Let me look for a stream and we'll just do it all. Let's just do it all. Do you guys want to see it? Do you guys want to see the Aubery verdict? Pop a 1 in the chat. It looks like y'all do. Let's go find a public stream. And let's find a stream of it and go find it. Who's streaming it? Is PBS streaming it? Y'all are like, yes. All right. We're doing it together. Let's see. Jury deliberations are continuing. We will return when the court is back in session. So PBS doesn't have it up yet. I will be monitoring it and I will switch over when they come up. So let me see if it's being reported anywhere on Twitter. And which stream it's being reported on. Because I'm not seeing, oh, jurors reach a verdict. The jury has reached a verdict. All right. Does it say what time they're coming back? No. No. No, it does not. All right. I will keep an eye on the PBS stream for sure to see when it comes back. I will actually, I'm just going to keep the volume up so I can hear it when it goes back live. We're going to keep talking about um the Britney motions, and then when that happens, we will switch over to that. Let me see if Long Crime has it as well. Are they streaming it? Yes, Long Crime is also streaming it. Okay, so we've got 2 streams that we can choose from. As those streams come back, I will let you know, and that's what we're gonna do. So, yep, we will go live when the jury is back. All right. We will continue with Britney stuff, and then we will switch to this. We're just gonna mods, I'm sorry. It's just gonna be a stream. I'll timestamp it when we switch over to the verdict. While we're waiting for it, I will stream it live. While we're waiting for it, should we just share that we're gonna do that too? Yes. All right, while we're waiting for it, we will just this is what live streaming is normally like. Normally my live streams are so like planned and succinct. Today's like a real just like go with the flow type of a live stream. So that's what we're doing. Where is what I'm looking for? All right. And I don't mean to step on any of the other law tubers' toes, but I had to move coffee and Cursey words, and now this is where we're at. All right, let me share that out because we're gonna watch it together. My. And all right. All righty, we're gonna send that out and we will just do that. I'm sure there are like 7 different law tubers streaming, but we're in the middle of coffee and Cursey words, so we're not gonna shift. All right. I am still on. I know you guys are saying the verdict is in. The jury has to come back in. There are things that have to do. So the streams are not up yet. I will be monitoring the streams and I will pull them up when it is time. Let us continue on instead of me just sitting here rambling. Let us continue with the Spears documents until it is time. And thank you for letting me know that that's happening. Thank you guys for monitoring the interwebs. So, back to Dad Spears for the time being, and then to Britney's new motion while we wait for this, and we'll just switch back and forth. All right, we're going with the flow. We're going with the flow. All right. Dad Spears yeeted Spears's nonsense. Oh, no, not yeeted Spears's nonsense. The feed for Long Crime has just opened up, so we're going to share that real quick. Let me make sure we're sharing it with audio.
Let's go ahead and get the panel.
All of these streams immediately started lagging. So I'm going to try it one more time. All of them started lagging. Hold on. You're going to watch me try to get this stream back up. Everything started lagging instantly. Ugh. All right. Come on. There we go. Nope. All right. Everyone is trying to watch. Yes, everyone is trying to watch. I'm going to do my best. I will look for another stream real quick. Let me share this. If we have to go audio only, I will go audio only. and we will listen. Oh, here we go. Hopefully you guys can hear it. Can we please just have a clean stream? That would be helpful. See if this one will play. Nope, long crime stream. See, everybody's streaming one stream, which is the problem. Let's see. Let's see if Reuters is streaming it. Theirs tends to go pretty well. No, they are not. I am getting a whole bunch of spinny. All right, they are waiting for the jury to come in. Let's try it one more time. This is not helpful at all. Yeah. Good times. Katya is saying PBC, and it's the, there we go. The jury's coming in because they all stood. I have sound being shared. I will continue refreshing and try to do my best to leave this up. All right. And let's see if Twitter has a cleaner stream. Thanks, you guys. We are trying to go to audio. There we go. It might keep buffering, but we will try. Everything is just spinning. So everybody's coming into court. It looks like we're caught up. And we're going to just keep trying. Thank you, chat, for keeping us posted. We will keep trying. I have absolutely closed everything. The judge is going to review the verdict forms and make sure that the verdict forms are accurate. And so that is what the judge is doing. So. And it keeps coming back up, so I'm not going to mess with it too much because it does keep coming back up. The verdicts should go from the judge to the clerk, and the clerk should...
The state of Georgia versus
there we go.
Travis McMichael. Jury verdict form. Count 1, malice murder.
Come on. Well, I am seeing you guys kicking somebody out for yelling. I'm not surprised. We are definitely lowering it. But this is why I normally don't do this, because it is such a pain to do. There we go. I don't know who they're kicking out. I'm going to see if I can find one other stream pulled up. And at some point, like, we have reset the computer. We have done all the things so it can co-stream, and it's just. So someone is being removed. I will try Crime Talks. There we go. That happens during verdicts. It's absolutely happened. So I've seen it happen. And if we need to go back and replay this, we will. But it looks like they are coming in guilty. I don't think they will split this verdict. So Yeah, I don't think they will split this verdict at all. Let me pull up one more stream and see if it's any better. But for me, it's just not working. There we go.
Dated this 24th day.
Well, long crime worked for 7 seconds. And I'm going to change the quality. There we go. And see if I can get long crime working. Nope.
Superior Court of Clinton County, State of Georgia versus Greg.
It is just not wanting to work. Every single one keeps spinning. So that's where we're at.
Case number CR20.
I'm trying to just make it small. Well, let's see. I will pull these up on Twitter as well and see what we have, because this is just being impossible. As we're like, we'll watch them come in. No, we won't. It is said, screw you, Emily. That's not what we're doing today.
Count 9, criminal attempt to commit a felony.
Just not at all. So sorry, y'all. I'm going to pull up. We'll try one more, but it's not playing at all. This isn't uncommon. I'm going to see who's pulling it up
We, the
on.
jury, find the defendant, Greg McMichael, guilty. This 24th day of November, 2021.
So we will go back and cover this.
Count 2.
There we go.
Felony murder. We, the jury, find the defendant, William R.
No.
Find the defendant, William R. Bryan, guilty. Count.
This is the individual that was recording it.
Count 5. Felony murder. We, the jury, find.
Nope, it's just not going to do it at all. So apologies, everyone.
We, the jury, find the defendant, William R. Bryan, not guilty.
We will go through these verdicts. Let's see if we rewind and just go through them cleanly, if that will help. But I don't think so. This is just a me issue.
Imprisonment. We, the jury, find the defendant, William R. Bryan, guilty.
Yeah, these are going to be all guilties. And this is a computer issue for me. This is not a, this is a streaming issue on my part. So Nate, the lawyer, is tweeting it out, but it looks like these are going to be guilties pretty much across the board.
William R. Bryan, guilty. Signed this 24th day of November by the foreperson.
And they will probably take everyone into custody. And I will rewind the stream a little bit and see if we can get a clean feed on this real quick. But it looks like they are going to be guilty on all of the charges. That's what I'm seeing from Twitter.
All right, ladies and gentlemen, I'm going to ask each of you individually.
He's going to poll the jury. So polling the jury, he's going to ask them if that's their verdict and if that's not their verdict. And in the polling the jury, if there's any anomalies in the jury, then you will see that if they say, no, this isn't my verdict. Remember, criminal verdicts have to be unanimous. So that's why he's polling the jury. I'm going to see if I can pull back in 10 minutes in the stream and see if it will run through cleanly. And if it will, then we'll do it. But so William not guilty. Okay. Defense has to pull the jury. They almost always pull the jury, so I'm not surprised by that. Let's see if PBS feed will come up. And if it does, then we'll just go through it. So.
Were these your verdicts then? And are these your verdicts now?
Nope. It's really frustrating that it just won't play. Ah! Yep, all right, well, I will come back to this feed in a few minutes and try to pull back in time and grab it, because it seems that I should be able to do that once this ends. So, we will see what happens, but it looks like on the main counts, there are felony murder. Why so many charges for felony murder? I have not looked at every single one of the charges, but normally they involve different circumstance. They don't all get sentenced together. So these lives just aren't playing for me, and that is what it is. So sorry, y'all. We're gonna go back to Britney, and then once this starts resolving, I don't know if it's me. It might be me that it just won't play video. Then we will go back. So all of these streams are just giving me a giant circling, spinning nothingness, which is really frustrating. So I continue to have this issue, which might be a my computer issue, trying to co-stream. There we go. Nope. See, every time I pull it up, it does. All right. So thank you, chat, for keeping everybody in the loop. And I will continue to work on why my computer can't stream and stream at the same time. I might just not have enough RAM. Darn it, do we need a new computer? All right, let me switch back to Britney stuff. I'm gonna have to timestamp it. Sentencing will be set for a while out. They will be taken into custody and then set sentencing dates. Let's get back to the Britney stuff. And I apologize. Because yeah, that's a bummer. But I will go pull those up and we'll just go through them afterwards if we can. Back to Britney. And if this feed comes back up, then we'll get back to it. I'll hear it if it comes back up. All right. We shut down everything. So I've got to pull these back up again. And then I will probably do a separate video with these objections. So it's just really clean and easy because we still haven't gotten to H3 stuff. It's going to be a long stream today. This is going to be a long stream today. Let's finish these objections and then we'll go over the other inaccuracies is where we were. Page 2, add a new paragraph 2 for accuracy and clarity. The temporary conservator of the estate, John Zabel, shall retain authority to complete the marshaling of all assets formerly under the control of Mr. Spears as former conservator of the estate and to take actions in furtherance of the petition for substituted judgment filed on November 12, 2021, including to execute any and all estate planning documents and to transfer any and all assets in the conservatorship to Ms. Spears's designated recipient consistent with the terms of the petition for substituted judgment and related terms. That means that's the new judgment in the case where the assets will get moved over. Paragraph 6 on page 2 inaccurately states that Ms. Montgomery's motion to seal the termination plan is set for December 8th. Ms. Montgomery's motion is set January 19th. We know that. The court moved it. Paragraph 7, starting on page 2, purports to list all pending matters that were continued on January 19th, 2022, but omits the petition for fees and costs filed by Ms. Montgomery on March 29th, 2021, seeking fees and costs for herself and her counsel. And then they ask that those objections be lodged. Let's see what happens in Britney's new motion. So let us swoop 130. Where are we? 138. All right, new Britney motion. This was just filed today, and now we've got it. So let's see. Superior Court of California, attorneys for Britney Jean Spears. So this is filed by Rosengart et al. Britney's objections to James Spears' proposed order following the November 12th hearing. Oh, let's get ready for some shade. Shade. Let's get ready for shade. Britney Jean Spears hereby respectfully objects to James Spears' inaccurate and procedurally improper proposed order, granting petition to terminate, denying petition to remove conservator, and setting future dates. Oh, that's the proposed order he submitted? What? No. Denying petition to remove conservator. They already granted that. No, 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 no. No, 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 no. Ms. Spears also joins in the objections filed by Jody Montgomery and John Zabel on November 18th, which capture some of Mr. Spears's misconduct, including his improper ongoing efforts to bolster his reputation and rewrite history, including his November 17th proposed order, which indisputably includes his September 9th suspension as conservator, a fact he cannot erase. Yes, he cannot. What is the footnote? Footnote voice. Against this backdrop, Mr. Spears's flawed proposed order requires correction. Ms. Spears also submits concurrently herewith a correct and accurate proposed order reflecting the court's rulings on November 12th. Oh, is it attached? Please have it attached. No. Because that was not on the court website yet, but I love that they are just fixing it. And then we will absolutely, once we're done with this, we will get back to the verdict. So we will get back to that soon because the streams were just not working for me. Let's see. Despite his efforts and proposed order, which makes no mention of it, Mr. Spears cannot avoid the stigma and consequences of his suspension, including but not limited to his objection to produce documents concerning his conduct while serving as conservator, such as communications concerning, among other things, his involvement related to the allegations from the recent New York Times expose regarding the iCloud mirroring of phones used by Britney to contemporaneously capture communications between Ms. Spears and third parties, and allegedly placing a secret listening device in Britney Spears' home or bedroom. So again, they are just saying, look, the order is wrong. He's trying to rewrite history. No more gaslighting. We're done. Objections. Mr. Spears' proposed order was filed in violation of the requirements of California Rule of Court 3-3.1312. Mr. Spears never having served it on Ms. Spears, Ms. Zabel, or Mr. Zabel or Ms. Montgomery before filing it with the court. He keeps doing that, and he's done that a lot. Yeeted Spears has filed things in court, and it seems like made them accessible to the media before serving them on the other parties. There is a service requirement. There's a reason there's a service requirement. It's so they can work this out before going back and forth in court. They can just call the other attorney and say, this is a problem, fix it before it gets submitted to the court. But he end-routed that and just went straight to the court, it seems. With regard to the content of the proposed order for accuracy and completement, page 1, line 8 should be clarified to provide that Mr. Spears is the former, now suspended co-conservator due to his September 29th, 2021 suspension. These are the same objections from the last motion that we went over. Page 1, lines 22, number 2 must be stricken as false and inaccurate. Contrary to Mr. Spears' claim, the court made no finding that the facts set forth in James Spears' petition are supposedly true and correct, nor could it have done so because Mr. Spears' petition was unfortunately replete with errors and falsehoods. Mr. Spears' attempt to slip this falsehood into the court record is not surprising, but it is inexcusable. In addition, for the sake of accuracy, this order should reflect the court's finding that all parties agree that the conservatorship of the person and the estate of Britney Jean Spears should be terminated. The date at page 1, line 22, referencing a non-existent October 4th hearing is incorrect and should read November 12th. There's a lot of inaccuracies. Page 1, paragraph 1 should be rewritten as followed for accuracy and clarity. Number 5013, the termination petition filed on September 7th, 2021 and joined by the conservatee is granted. The conservatorship of the person is hereby ordered terminated, effective immediately, subject only to the further other orders made herein. For accuracy and clarity, a new paragraph should be added, clarifying that notwithstanding the termination of the conservatorship effective November 12th, the temporary conservator of the estate, Zabel, shall retain authority to complete the marshaling of all assets formerly under the control of Yeeted Spears as former conservator of the estate, and to take actions in furtherance with the petition for substitute judgment filed by Zabel November 12th, including to execute any and all estate planning documents pursuant to the petition for substituted judgment and transfer any and all assets to Ms. Spears' designated recipient consistent with the terms. Paragraph 2, page 2 is incomplete and misleading and should read, based on the conservatorship having been terminated and Mr. Spears having already been suspended on September 29th, the petition to remove James Spears, filed January 26th, is moot and denied without prejudice, which is great because it sounds like Spears is trying to put into the record that the petition to suspend or remove him was denied versus it wasn't moot. So it's moot because he's already been suspended. I love that they are trying to clarify. Paragraph 3, page 2 is incomplete and misleading as written and should read, based on the conservatorship having been terminated immediately on November 12th, the petition to appoint subsequent successor of the estate, and then it would go back to whatever it said before. That's what the ellipses should mean. Paragraph 6 of Mr. Spears' proposed order contains a typographical error. Ms. Montgomery's motion was filed in 2021, not 201. I love that they're just like, here's the typos. The proposed order should include the following information for accuracy: that the petition for substitute judgment filed by Zabel on November 12th, 2021 is set for December 8th at 1:30. So this is, again, 2 objections now. And these 2 objections saying, look, Dad Spears is trying to sneak shit into this proposed court order that's not accurate, and the court can't sign this order. It has to be accurate. I think the court will just adopt the order that was submitted by Rosengart for the sake of being thorough and safe. And we will see that signed. And when we see it signed, I will share it on social and talk about it on a live stream because it will be signed. It will be submitted. We should be able to see it once that happens. So let us move on. We need to move on to H3 stuff. And then I will circle back around for the verdicts in the Aubery case. I'm sure they will be reported. I could not co-stream, tried it, didn't work. My computer said negative ghostwriter. So it was either my computer, it was not the internet, because the internet here is quite strong. So that was a computer issue. We will be dealing with it. Do not you worry. All right. Let us move on at an hour and 46 to the H3 stuff. Are you ready? And then we will come back and swoop the verdicts real quick. Triller is being all Triller-y. Are we shocked? Are we shocked at Triller being Triller-y? Negative, ghostwriter. We are not shocked. Since I shut down all of my documents, we're going to have to pull stuff up again, but that's okay. Let us get to the Triller of it all. Here's what's going on in the Triller lawsuit. If you have been following along, Triller streamed the Ben Askren fight on their app and in other places. They're accusing Mike, and others of copyright infringement, essentially for restreaming or ripping the stream and re-uploading it and all that stuff. The case has really popped off against H3. The original case against Film Daily was dismissed for failure to prosecute. Triller never found who Film Daily was. They didn't know who to serve. They didn't serve it. The court, the very sassy Judge Anderson, dismissed the case without prejudice for failure to prosecute. So right now, the Triller cases that are moving forward that we've been following are against the H3 podcast, Ethan Klein, their production company, Ethan Klein. They're trying to loop in Teddy Fresh and others. There are 2 cases. There is a California state case and there is a federal case. The federal case has now been put over. I think the federal court is waiting to see what the state court does, but it could be a scheduling issue. There's a motion to dismiss in the federal case that has been put over until April 2022. So we will come back to the federal case later. The federal case is the basic copyright case. The state case is the Reddit foot soldiers, we're mad that you said Ryan Kavanaugh looked like Harvey Weinstein case. And that case is moving forward. There was just a hearing on the slap motion. Now, the slap motion was brought by Ethan Klein as the defendant, saying, look, Triller is trying to sue us for protected speech. What you can't do is sue us for that. So the court just had a hearing on the 19th of November and issued an order and a ruling in that hearing. I have a playlist covering this. We've covered all of the motions. You know how I feel about the motions. There are numerous things being alleged in the lawsuit, but in those things being alleged, what we haven't seen really is stuff that the court keyed on in this hearing. And the reason we know that is because the court attached a transcript. And I read the entire thing last night. Oh, let's get to that, and then we will swoop back and then get to Q&A. It's just going to be a long stream today. Thanks, mods. Can you guys send mod love? Don't forget to like and subscribe. If you're subscribed, you'll be able to chat. We have subscribers only mode on. There are over 3,400 of you, so you can just do the likey, subscribey things. All right, let me get some water and let's get into this. All right, with regard to the hearing on the slap motion, the court issued a very brief order. And here's what the court's order said. On November 29th, 2021 at 3 p.m., Triller and the defendants shall concurrently file briefing not to exceed 7 pages on the issue of the propriety of the court granting Triller leave to submit additional evidence at this stage of the proceeding for the anti-slap motion as to the items and issues identified by the court at the November 19th hearing. A true and correct copy of the transcript is attached as Exhibit A. So the court is saying that, look, I know that Triller needs to submit more information. Triller cannot survive this anti-slap motion if they don't submit more information. But should I allow Triller to submit more information? And can I allow Triller to submit more information? The argument from Ethan Klein's side is going to be, this is the point of an anti-slap motion, to get rid of vindictive litigation early, to clear out things that are bullshit that can't be proven. Because if Triller can't show they have an itty-bitty chance of winning this on the merits based on their pleadings and their motions, they don't get another bite at the apple. They knew what this motion was. They knew what was coming up. They knew what they had to prove, and they failed to do it. So no, they don't get to add more information. Dismiss this case. What Triller is saying is, well, Your Honor, if you're confused about this, I can add more information. Please give me leave to supplement my opposition. The opposition should have been full. It was a very long opposition. They submitted an entire printout of all of these different reviews that they're saying are attributed to Ethan Klein. I think the court is inclined to dismiss this case, to grant the anti-slap motion. And I don't know why the court didn't just say, we're done. I don't think the court will allow more briefing. I think the court is at a place where they have to stand by the briefing that was submitted by Triller. Triller's attorneys knew what an opposition to a slap motion was. They knew what they're obligated to prove, and I don't think they will be allowed to file additional briefing. If they are allowed to file additional briefing, then that briefing will go into December, and there will be a second hearing on the anti-slap motion. So on November 19th, we will see those additional filings. No, on November 29th, we will see those additional filings, and then we should see a ruling on that the next week. So I will be checking back on this the first week of December. Let's get to some of the things that were argued. By the law firm of Novian and Novian. This is the same firm that is in the federal case that filed the initial complaint that I'm like, ugh. So this is I pulled up the wrong transcript. Hold on. This is not the one with my notes on it. I hate how small these transcripts are. They make it difficult. No, let me pull up the correct one, the highlighted one, because that's the one I want. See, when I had things pulled up and then we got all discombobulated, and we will recombobulate. Are we recombobulating? I feel like that's what we're doing. Let us get to the highlighted one, because that one's going to be easier for all of us to see. Yay. These are so hard to cover because the type is so small. So I'm going to go through some parts of this that are important, and then we will go from there. So the court took their appearances. These transcripts go page 1, page 2, page 3, page 4, as opposed to going this way, which is always difficult. The court gave their statement of opinion first, which is very interesting. Kristen, I know we tried to cover it. We will get back to it after we finish this. I'm waiting to go back in the stream and waiting for the reporting on it because the stream would not play. We tried. So thank you. The chat has let us know. The court said, all right, good morning. Okay, so we're here on defendant's this is going to be hard. Anti-slap motion. You want to know if there's a tentative, and this is an oral tentative, meaning the court is giving what they are thinking. The court says, I have read at least once the entire file. I've watched the podcast. So the court has now watched the H3 podcast. I was delivered a flash drive. I've watched the podcast at issue in the complaint. I don't need you to address everything. This is a two-prong analysis. I find that these activities, that the speech that took place in a public forum, and that was part of the contention whether YouTube is a public forum where speech might be protected. The court goes on to say that the internet is an electric bulletin board open to literally billions of people all over the world, and that the YouTube platforms, the subreddit platform, which was open to the public. So my initial thinking is that this was a public forum. I find the activity and the speech at issue in plaintiff's complaint was of public interest, but I'll find that Triller is not a mom and pop operation. Triller, as described in the pleadings, gets significant media attention from other than just the podcast, but from Variety, the New York Times. It's a very large company with a significant numbers of employees. So Triller is of public interest. The plaintiff here needs to show me and then the defense attorney interrupts. Oh, wait, no, I'm jumping pages. Wrong. The plaintiff here needs to show me even a minimal probability of success on the merits, and I need to hear argument on that. When the court says you need to show me a minimal probability of success and I need argument on that, it means you are losing. It means that the court does not find on your moving papers that you have any potential to succeed on the merits. And that is what the court said. The court said, when I look at and analyze every single cause of action, I am having difficulty finding that the plaintiff has met a minimal burden of satisfying that two-prong criteria. I'm not weighing the evidence. I'm crediting plaintiff with the evidence that they present. And that's what happens on this motion. Much like a motion to dismiss, all of the evidence is weighed in the light most favorable to the non-moving party. The defendant, Ethan Klein at H3, is trying to get the case dismissed on an anti-slap motion. The plaintiff then gets the benefit of all the evidence. If the shit they're saying is true, could they win? And the court is struggling to see that on this. So that's where we're at. The court is really struggling to find that the minimal burden has been met. And the court says minimal burden more than once. I am struggling to find that plaintiff has presented evidence on the elements of each claim to satisfy its minimal burden on prong 2. So the court's already inclined to grant the anti-slap motion from the get-go. Then Triller's in blue, Triller's attorney starts giving their statements to the court. Triller's the one who has to prove a minimal burden. They found essentially that Ethan Klein and the defense has already proven the minimal burden that they needed to prove. So what happens in an anti-slap motion is that we have to prove, like, the defense has to get past prong 1. The court's like, prong 1's been met, we're there. Once the court gets past prong 1, then the burden shifts to the plaintiff to prove that they have a minimal probability of success. And the court is struggling with that here and struggles this entire transcript to find that. So that is the kind of position of where this is. All right. The defense starts out by arguing that the statements made by H3 are false statements. And then they say because they are false, they necessarily cannot further the public discourse, which is a requirement under prong 1. So the court said prong 1's been met, and the defense said, no, not prong 1. And the court said, hold on, because I need to be cited to where this is because I missed it. It's possible I missed it. Are you saying that the defendants conceded that their statements were false? The Triller attorneys that go on to say, yes, well, yeah, well, defendant concedes that his own review, remember the review of the Triller app on the App Store, the Ethan Klein review, as we refer to it, or the Ethan K review, as we refer to it in the papers, defendant acknowledged that that was false. Let me point you to the portion of the papers. So here on page 6, footnote 6 of defendant's reply, he says in comical fashion, Triller argues that he's in review of the Triller app as a false statement. The reporter said, slow down. And they say defendant writes in a comical fashion, Triller argues that he's in review of the Triller app is a false statement by itself, which makes no sense. Then defendants go on to explain that no reasonable person would believe that the defendant's review is true. In other words, it's an inflicted admission. It's an inflicted admission that the review is false, Your Honor. And then the attorney for Klein says, objection, that misstates and the court says, I don't want you to interrupt while he's arguing. The thing is, they're not in front of it. They're just in front of the court. So if people say things that are objectionable, then you have to get back to it. I don't want you interrupting while he's arguing. I'm going to give you the opportunity to address anything he says, okay? And the attorney for Ethan Klein says, understood, my fault. Like, my bad, Your Honor, but he's like I had to object because he's so full of shit. So then the court says, so you're saying that the statement, no reasonable person could believe it's true, or words to that effect, is a concession? And Triller says, as the defendants write it, and I will use their words, this is what they said in court. This is from the court document. Get ready. Get ready from the transcript. This is what Triller's argument said in court. I will use their words. It is farcical for Triller to argue that any rational person would believe that Ethan's review made a statement of provable fact when he said he would prefer a colonoscopy from a chain link fence, a dirty Sanchez on a scorching day in Death Valley, or to listen to David Dobrik's Luciferian demon laughter play on loop till as his ears bleed for using the Triller app. Such a statement cannot be construed as asserting a statement of fact. Let's just go. Is this a factual statement? Is it a factual statement that Ethan Klein would rather receive a colonoscopy from a chain link fence, a dirty Sanchez on a scorching day in Death Valley, or to listen to David Dobrik's Luciferian demon laughter play on a loop as his ears bleed? Is that a statement of fact? No, it's hyperbole. And the court says that Triller is trying to argue that because it's so outlandish, it's clearly false. But it's not a false statement. It's not defamatorily false. It's hyperbole, which is different. So the attorney's argument is just so disingenuous. The court says, but isn't hyperbole protected? Like whether or not Ethan Klein would prefer a dirty Sanchez on a scorching day in Death Valley is not at issue. It's hyperbole. Also, it's opinion. Also, maybe it is a fact. I think he might rather get a colonoscopy from a chain link fence. Maybe. The court goes on to say, isn't hyperbole exactly one of the things that is protected by the First Amendment? Hyperbole, over-the-top opinions, humor, attempts at humor. I'm not saying that it was humorous. Okay, y'all can decide for yourself if you thought it was funny. Triller then says, Your Honor, defendants knew much more than these at false review. They encourage others to leave similar false reviews in an effort to harm another business. This lawsuit is not about speech, Your Honor. It's about conduct, leaving thousands of similar false reviews in an effort to sabotage another commercial enterprise. The court says, so if that's the case, are you really talking about incitement? And they did not plead incitement. They talk about seeking to interfere with the business, spamming the things. They talk about the contractual relationships. The court isn't having it. The court says, let me stop you for a minute. One of the things I'm struggling with, counsel, is what is left to speculate as to what Triller's business model is. The court is left to piece together on its own because it did not find evidence of an economic relationship we're being referred to. were the economic relationships, and this is all speculation on the part of the court because the court does not know Triller's business model. It was not presented as far as I could tell in the pleadings. Triller is trying to argue that people saw the one-star apps and didn't use the app, but they're trying to prove interference in an economic relationship. And the court is like, what economic relationship? Who's using the app? If people are choosing not to use the app, then that's not an economic relationship because nobody chose to enter into the economic relationship. So the court goes on to say that the business model was not presented, and I don't think Triller can prove that they have an economic relationship with people that have chosen not to download the app. And I don't think they can prove that people choosing not to download the app is because of these one-star reviews. I don't think they can prove that. And that's what the court is saying. What business relationships were disrupted to cause economic harm that the defendant's actions were a substantial factor, for example, in causing economic harm, disruption of relationships? The court's left guessing. When the court's left guessing, your motions have not gone well. The court was not provided with information, admissible evidence, as far as I could tell, on damages other than a conclusory statement. And for example, how many users does Triller have? What number of users are no longer using Triller? There's never really an estimate. I'm not saying you have to prove your entire case right here in your opposition, but you have to provide me with something. Oh, Triller, what percentage of your business did this conduct that you describe in the complaint, what percentage of your business does it impact? Does Triller have millions of users? If Triller has millions of users, what occurred here de minimis, or was it significant? There's a reference to the glass deposition to millions of dollars being lost. That's a conclusory statement. So I'm happy to have you address it. And then Triller's attorneys go on and on and on and never address it. The court says, because I do not understand why you wouldn't put that into your initial opposition. Exactly, which is why they shouldn't be allowed to supplement it, because they didn't understand the assignment. And that's on them. They're the lawyers. The court said, I don't understand why you didn't put it in your opposition. In order to even consider that counsel, you'll need this morning. The first step is for me to give me an offer of proof now what your supplement would show. Because now they're saying, well, can we add more? Can we add more? And they shouldn't have the right to. They say it's difficult to quantify the exact number of potential users. Potential users is not interference with economic relationship. That's a potential. There's no relationship there yet. The court said it's difficult to quantify, but you're telling me your offer of proof is that you have more detailed information, counsel. Let's see. He goes on, we can show you what the conversion rate is in the months before the defendants launched, as they call it, a war against plaintiff. Again, the conversion rate changing could be a lot of factors, not necessarily this factor. The court then said, do you have an offer of proof on how you can even make a minimal showing of causation as to actual damages? The court is inclined to dismiss this. They say, Your Honor, we would show that there is simply no other cause but for this. How? The false and misleading one-star reviews are linked demonstrably to the defendants by the words that are contained in them. But how is that linked demonstrably to the decline in the case or the decline in the conversion rate? The court, okay, so I'm just trying to understand the argument. What I hear you saying, and the court keeps interrupting because the attorneys aren't doing themselves justice because they can't fix this because they don't have the ability and the facts on their side. The court said, are you telling me that shows actual damages? Okay, so the court said, well, what you did in fact present evidence of was a log starting after the podcast aired, correct? And it listed one-star negative reviews in the Apple and Google app stores. Is that correct? And you're telling me, the court goes on, that shows actual damages. The attorney for Triller says the depressed conversion rate is evidence of actual damages. No, conversion rates are a potentiality. The court then says, I understand that is what you've alleged, but aren't you stopping short of telling me what the revenue stream was actually disrupted, causing damage, financial damage, the millions of dollars that are alleged in the declaration? Where's the, and then he gets interrupted. There was no details provided as to how, whether what I hear you saying now is the relationship has been disrupted by this war, as you describe it, is because potential users was interfered with the conversion rate, the potential users. So I still don't understand and Triller's business model to know if Triller's been damaged. I still don't understand the revenue stream. And the court says over and over and over, prove to me your damages. And they keep saying, but they did it. The court continues on saying that this is a very low standard, but you need to show some standard. And then they say, we're happy to seek leave for a supplemental briefing, but this should have been in their opposition. The court goes on to say, I'm struggling with evidence of who's the contract with, for example, in a number of these. And he tells counsel for Triller again, tell me what the causation is. The court says I'm struggling over and over and over because Triller can't prove it. As we said, just to reiterate, there's been no evidence of the source of Triller's profit. And then the attorneys continue to go on and say, well, the lower conversion rate connects to lost profits, but they don't actually say any profits have been damaged. They then switch tactics and the court is like, no, I understand the sequence of event. I'm really struggling to find the evidence. The court interrupts again and says, excuse me, that's not what we're addressing. What the evidence that I don't see and that I need help with is causation. How did these reviews cause you damage? Show me the money. Where is it? What did you do? And the court keeps interrupting and they keep trying to argue side information and not addressing the court's questions, probably because there isn't any causation, which is something we talked about when I covered that motion. You've given me 2 logs that show similar language to the language used in the podcast and that the 1-star reviews have similar language, but that's as far as it goes in terms of connecting the dots. But I think we've discussed it. Anything further on this point or on prong 2 you would like to give me now? And they ask again for leave for more. And talking about the ratings in the App Store, there is no other circumstance that we are aware of or that the defendants have identified to possibly explain the change in the app's rating and the lower conversion rate, as the Black Declaration attest is based on the lowered app's rating. And the court says, okay, let me ask you this. I hear you. Okay, I hear you. Can it be assumed that the app users, there's a certain behavior that app users may have? None of it was presented here, but do app users come and go? I mean, I don't know what is presented periodically. Do app users get dissatisfied if a camera is inverted? The court asked Triller's lawyer, yeah, but is it flipped? The court asked Triller's user, could app users be upset because your shit is flipped? The court said, but was it flipped? Oh my God. Yeah, but are users dissatisfied if a camera is inverted or whatever the issue that was raised here and go somewhere else and then come back? Do app users get mad because it's flipped? The court is not having this at all. The court, yeah, but your shit's flipped. I'm living. And then Triller's attorney says, to that point with the inversion issue, Your Honor, that's a great point. As we showed in our moving papers, that inversion issue was affected only one type of phone, an Android or an iPhone. I don't recall which offhand. Know your shit, man. But to the extent any reviews mentioned that and attributed the low review on the other app store, that is necessarily a false review and not the reason for the false review. On to the other point, the inversion issue lasted only a limited time and was resolved long before defendants began reiterating that claim. The court said, okay, I'm talking about app user behavior, which I would love to speculate on, which I wasn't going to do because it wasn't provided to me. It's all the discussion on causation here, but thank you. Causation meaning show me that what the review said caused you harm. Prove that there are damages. Because the court's like, I'm struggling to see damages. I don't see how these reviews called damages. I don't think you can prove damages. So I don't think you can survive this anti-slap motion, which means if the anti-slap motion is granted, then Ethan Klein gets attorney's fees from Triller. Triller has to pay Ethan and H3 because they brought this lawsuit and lost on an anti-slap motion. The attorneys again go round and round and round, and the court says, okay, very good. And this has been helpful. I doubt that it really has been. The court continues to say, I'm not struggling. I'm not suggesting that you amend and file a cause of action for incitement. I'm just saying that my job is to look beyond the language, but I'm not telling you to file anything. And then it moves on to H3's lawyers saying that the plaintiff's prong one argument that false speech does not qualify for protection under the anti-slap statute is false. They go through the law showing that that's a poor argument. And the court said, no, I really want you to address prong two because prong one's already been proven. H3 met their burden on this motion. The weight is now on Triller to prove that they can succeed in some way. And they're not, I don't think, going to be able to do that. They go on to argue about the speculative damages, the fact that there's no causation between the two, the link between causation and damages being too tenuous, that leaving a one-star review is protected activity and protected speech, that Ethan and the podcast did not tell other people to leave one-star reviews. They said, yeah, give it an honest review, give it time, give it your honest take. I gave it 1 star based on my experience. And Dan said, right, that was your experience. Your mileage may vary. You may enjoy it more or less. And so they were telling people, leave a review, only serious reviews. They go on to talk about why an incitement cause of action shouldn't be pled. It's not here. They go on to cite other cases about people being held responsible for actions where there's not causation, well, not being held responsible where there's not causation. They then start talking about the conversion rate. The H3 attorney compares the conversion rate to like somebody's window shopping and chooses not to walk into a store. So they walk by the window and then they don't go in. Okay, well, some people choose not to go in. What do you attribute that to? And how is that damage? That's not a customer that you had and lost. That's a customer that you didn't gain. So that's why they're trying to prove, did the reviews cause damage? And so far, they are saying that Triller has not proved that in this case. So, they go on to talk about speculation. And so in turn of loss of actual users, again, they admitted that it was glitching. They admitted that the whole line, yo, Triller, my thing is flipped, was true. And so in August, sometimes they decided to fix it. So the thing was flipped. That's fact. They go on to talk about the supplement and that they shouldn't be allowed to file a supplement. The court goes on to say over-the-top hyperbole is also protected. The court really seems to be leaning towards granting this anti-slap motion against Triller. They go on to one of the other claims, which is more of the same. I want to see if there's any they go on to argue that Ethan Klein's review is false because it's not based on downloading the app and using the app. They say correct. I argued from the beginning that they admitted that the review was false. Ethan would not actually prefer, a colonoscopy by a chain link fence. So they're trying to say hyperbole is a false statement. That's not going to fly with this court or any court. The court continues saying the court is struggling to find that, or was struggling to find that plaintiff made a minimal showing of probability of success on the merits. And goes on and on. And then they say, okay, I will let you brief it. The court, I don't know why the court let counsel beat them down, but the court said, I will let you brief the issue and submit more. The court said, I want to give you a full opportunity to let me know if I have the discretion to do this and why I should accept late evidence at this late hour. I'm going to determine once I receive it on the 29th. I'm going to set a future hearing date depending on what I rule because the calendar is so crowded. So the court is going to look at a motion from both sides to see if they will allow Triller to supplement their evidence. That is what their opposition was for. Everything should have been presented to the court on that opposition. Most courts would have just denied it. Most courts would have said, no, you're done. You're done. And then they pick a date for the next hearing, and the supplements will be coming in on the 29th. The court is not inclined to grant this at all. They're just not. All right, I'm going to see if I can pull up a Twitter video from CBS to see if we can go through these verdicts real quick in the McMichaels case. I don't know if it will work. We are at 2 hours and 19 minutes. I will try. Let's see. If I pull this up and it starts spinning, I'm just going to lose my mind. Yep, spinning. 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 I've tried. My computer is not having it today. So this is on Twitter. Let's see if the the text-based breakdown of the rulings is there, because it should be. Let's see. There should be a breakdown. Let's see. None of these videos are working for me. All right, let's see. USA Today has a breakdown. Let's see if that will work in reader view. Let's go. Let's go reader view. Nope. That's a terrible reader view. The amount of frustration. Let's see. Do we have all right, here we go. Here's a breakdown of the charges. Let us swoop and get to it. All right, since we talked about it earlier, we're going to get to the breakdown of it's time for a breakdown of the convictions in the McMichaels case for the killing of Ahmaud Arbery. Let's see. Father and son Gregory and Travis McMichael and their neighbor William Rhodey Bryan each faced a total of 9 counts, 1 count of malice murder, which is like a first degree, 4 counts of felony murder, 2 counts of aggravated assault, 1 count false imprisonment, and 1 count of criminal attempt to commit false imprisonment. The jury found that Travis McMichael, who shot Aubery, guilty on all charges. Gregory McMichael was found guilty on all charges except malice murder, meaning the intent piece was missing. So then guilty on the felony murder, not guilty on the higher degree of murder. Bryan was convicted on 6 of the 9 counts, including 3 counts of felony murder. So the 3 counts of felony murder, because there was only 1 killing, the 1 victim being Aubery, those will get condensed. It's like the 3 different felonies that they committed leading to the homicide. So that will not get sentenced altogether. That will get sentenced afterwards. So, or not concurrently, because it is 3 different felonies, but just 1 homicide. Defense attorneys argued that the men are not guilty of these charges because they were attempting to make a citizen's arrest. That was a legally faulty defense. Under Georgia law, felony murder is committed when a person causes the death of another person while committing a felony. Malice murder refers to when somebody causes the death of another person unlawfully and with malice aforethought. That's your first degree. It's called first degree in a lot of jurisdictions, your intentional homicide. Express malice is a deliberate intention unlawfully to take the life of another human. So they did go through the state of mind with these. And when they went through the state of mind, they did say some had the state of mind for the malice murder and some did not, which I think is a jury being thorough when they can find a state of mind to one and not to another. We know what the aggravated assaults were. The citizen's arrest was not persuasive, because if the citizen's arrest was persuasive, then you wouldn't have had the convictions. So prosecutors argue the defendants didn't have immediate knowledge that Aubery had committed a crime, but instead made assumptions based on neighborhood rumors. They also said none of the defendants told Aubery or the police that they were attempting to make a citizen's arrest. And then self-defense. In Georgia, a person can threaten to use deadly force if they reasonably believe it's necessary to protect themselves. Although Aubery was unarmed when he was killed, defense attorneys argued that he could have used his fist as a weapon. Walmsley told jurors a person can use their fist to commit aggravated assault, which would be considered a forcible felony. The jury clearly did not believe that. Walmsley said that a person cannot claim self-defense if they are committing a felony, if they provoked another person into using force, or if they are unjustifiably the initial aggressor. I think the jury, based on these verdicts, found that they were the aggressors, not Aubery. And so that is the conviction. There are links on Twitter to watch those. Unfortunately, my computer will not play them. I am going to take some questions and then we are going to get on to getting on because it has been a long one and a lot of you are getting ready for Thanksgiving. So it's just been. So those are the convictions. Earlier in the show, I talked about the fact that I would be very surprised if there were acquittals on this case, that I would be the evidence seemed to me more likely that there would be convictions. I'm not surprised that some were convictions and some were not. I think that it is it's appropriate to go through state of mind and find which state of mind they found. I think this was a considered verdict. This was a verdict that was I don't know how I can say well thought out. I wasn't there, but it was a thought out verdict where they went count by count, evidence by evidence. And that's exactly what you want from juries. You want them to be thoughtful. And it seems that that's what the jury has done here. So hopefully, I mean, that never brings anybody back. That doesn't make it right, but at least hopefully it feels to the Aubery family that justice has been done for the murder of their loved one. So that's what I'm hoping. I'm hoping that there is some relief and feeling that justice has been served in these convictions. All right. I have questions. You have questions. We have questions. We have questions. Questions at 2:25. Look, the legal shit's been so busy, y'all. I'm going to try to get to some of the super chats that I missed. I had closed everything to try to get streaming to work. I'm going to have to figure it out. I have done a lot to try to get it to work, but it's still not working. So I will probably do a test stream with the members to try to figure it out, or we might just need a new setup. I'm never mad about buying new tech. Let's be honest. I'm never mad about buying new tech. Also, there will be a new Emily Show episode. It is out today on your favorite podcasting app. It will be out on video. I will populate it either later today or tomorrow, or maybe Friday. We will see. We will populate it soon. Let me pull up these super chats so I can see all the ones I missed. I know I missed some early on in the stream as we get to questions, but everything now needs to be pulled back up because I closed everything. I closed all of it. All right. These should be quick. Unicorn Poop, thank you for saying hit that like button and show the love. Don't forget to do the YouTube things. I always forget to ask, but do the YouTube things. Haley said, I feel so uneasy about the jury consultant who worked on the OJ case. Why is it okay to look at demographics of a jury for better chances of an acquittal? Haley Davis. Oh, yes, that's what jury consultants do. It's what political consultants do. It is understanding the jury pool that you might get is part of tailoring your case to a jury so they can hear you. That is part of trial work. So, yep. It is not illegal to have jury consultants, and I don't think it will be. So hopefully that answered your question. Cabria Cousins said, hi, Emily. Are you or any of the law tubers covering the Ghislaine Maxwell trial next week? I don't know who's covering it. I haven't decided if I am. We'll see. Darla said, so really, James is wanting to have the conservatorship of his daughter. Yeeted Spears is getting wild, Darla. I don't know. Wild. Susan Bortz said, if Britney set up the trust with instructions before the conservatorship, how can dad change those? Isn't that the whole point of trust? That's a great question. The trust was set up during the conservatorship. So he set up that trust, which is why they are setting up a new trust so that he has no tentacles in it. Mauricio, thank you for the super chat. Swift kick. Yeah. Yo, Your Honor, my thing is flipped. Exactly. My thing is flipped. So that is what that is. Um, Question, did you see the judge put Alex Murdaugh in a receivership? I did not, but I'm not surprised by that. So I did not see that yet, but I will go look for it. Let's see. Sinister Moon said patience of a saint went out the window with this channel. It is now patience of the mods. I mean, we try to be patient, but also fuckery gets yeeted. Because it's hard when you're talking about topics that are polarizing. We are here to have considered conversation, but not to just have name calling and not to just be like, this sucks, that sucks, I hate this, fuck that. We're here to have a conversation and then have feelings separately. We can do both. We can do both. Humans are very complex creatures capable of advanced levels of thought, and two things can be true at once, and you can understand the facts of something and also have feelings about the thing. So that is where the patience comes in. Question, how hard would it be for Ethan Spears to scrub files and hide his wrongdoings, or how much has he made off of her? I don't know. I don't know how hard it would be. I don't know where those things live. But there are, in conversations, there's more than one person. So if it shows up from one and not from the other, then you're going to see that it shows up from one and not from the other, and that is going to be a problem. So let's see. Question, any view on the outcome of Drake and Travis Scott's $2 billion lawsuits? There are so many lawsuits in Astroworld. I don't have enough information to tell you what I think about it just yet. I've seen all the allegations in the lawsuits. I've covered them on the Emily Show. I will continue to cover them, but I need to know more before I have a thought. So the evidence is still coming in. Any chance the Emily Show could be made available on Deezer? I have no idea what Deezer is. So it's available on most podcasting apps, but I will take a look. So, question, are you going to report on the movements in the Murdaugh case? The judge is following the money, and his law partner and brother both sued him. I have 2 videos on it, and I have been covering it. I have not swooped back around to it. So we are definitely covering it. All right, I'm going to do a few more questions, and then my voice is starting to be exhausted, and I have to start cooking a bit for tomorrow. From Brisbane, Australia, why hasn't Jen Shah charges not included elder abuse from Marta? Marta, there is an enhancement on the indictment based on the age of the individuals. So elder abuse isn't the right fit because it's not financial elder abuse because it is a fraud case, but there is an enhancement based on the age of those that were victimized, and that is in there. So the separate charge is not appropriate based on the facts that we have, but there will be a sentencing enhancement for that if that's found, and it's one of the things that Stuart Smith pled to particularity with and said that was done. So yes. Question, have you been keeping up with, okay, we talked about Murdaugh, and I will get back to that, but yes, I covered the lawsuit from the partners when I did my big breakdown of it. Your hair looks gorgeous today. Thank you. We're just it is, yep, that's what's happening today. But thank you. Thank you. I will put up a poll and see if people want to do that. So let's see. Question, what is a receivership? It's generally like a bankruptcy, but like a step before a bankruptcy. Will I cover Depp and Heard? Yes, it's a lot to catch up on, but I covered the UK part and I will cover more on it. When do we get an update on our Caterpillar case? Friday. The Emily Show is on iTunes. Well, it's on the Apple Podcast app, and it is on, so it's on Apple Podcasts. It is on Apple Podcasts, and it is on the Audible podcast and Amazon and Spotify and all of those. So that's where the Emily Show lives. Question, how many cases do DAs handle yearly? How busy are they? DAs are look, I only worked in LA County and we were perpetually swamped. It depends on the assignment. There were assignments where I was handling over 100 cases a day. And there were assignments where I was carrying a load of like 60 fairly heavy trials and then handling a daily caseload. Lots and lots and lots. And I guess the mileage may vary depend on where you're assigned. Too many most of the time. It is definitely a juggle of cases. So, and it depends on the assignment you're in, the courthouse you're in, but lots and lots and lots and lots. Y'all, it is Thanksgiving time. The mods have given so much time today. Thank you, all of you, for being here. Sorry for the tech hiccups. I'm going to continue to work on that. I have reset things and refresh things, and it is still coming up an issue. Sometimes it's just not meant to be. And I will try to figure out, it's not an internet issue. I do think it's a computer bandwidth issue. So I will try to figure out co-streaming so that we can do some more live reacts, but it's a lot. So have a wonderful Thanksgiving. I will be posting the Emily show. I'll probably post it later today, so y'all have something to watch tomorrow. And then I will be live on Friday with Dr. B. That is the plan for now for Friday Night Live, to have a chiller stream where we're not covering super heavy stuff and talking about internet drama and chatting with y'all. So that is the plan. Thank you for being here. Thank you for being law nerds. Thank you for this very long stream. Huge thank you to the mods. Don't forget to like and subscribe on your way out. Have a wonderful holidays. And I will talk to you soon. I know for all of you that are celebrating Hanukkah, it's like Thanksgiving and then Hanukkah right on the tail of it. Lots to celebrate, and lots of family time. And hopefully you get to be with those that are important to you to be with this holiday season. I appreciate you being law nerds, and I will see you around the social medias over the next few days. Take care. I appreciate you. Be good to each other. Be good to yourselves. Family can be hard. So enjoy. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.